Hello, my name is Michael Tesoro and I prepared this video case note entitled Checking Out the Checkout Case. So I'll be looking at the recent civil case in the Supreme Court of the Checkout and Cordell Jigsaw productions. Effectively, it's a case between the two individuals behind the Checkout series on the ABC, Mr. Morrow and Mr. Murray. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice for 14 years now, and I help companies with competition and consumer law issues. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including in enforcement and mergers and asset sales. Now, the outline of the presentation, I'll start with the facts of the case, look at the allegations and the findings made by the judge, and then finish with a bit of commentary. Now, Justice Stevenson starts the judgment with this really, I think, excellent sort of summary of the facts, and it reminds me a lot of Lord Denning's approach in the UK to his judgments. As you can see, they're short one-liners setting the scene for the particular case. So Mr. Julian Morrow is a television writer, performer and producer, and well known for the Chaser series as well. Nicholas Murray is a television producer, probably best known for the Gruen transfer. I think he was behind that. Both Mr. Morrow and Mr. Murray legally qualified, although neither is currently in practice as a lawyer. I'm not too sure why that was thrown in, but might explain some of the vigour with which the two parties approached the litigation. In December 2010, Mr. Morrow and Mr. Murray agreed to work on the Consumer Affairs program, led to the checkout. It was a success. During 2019, Morrow and Murray fell out, and I like that, bitterly. And then finally, the proceedings are about the consequences of this falling out. So that sets the scene pretty nicely as to what the case is about. Now, the facts are that in 2012, Morrow and Murray set up these companies to basically work on this new production, and they set up this joint venture company. So the giant dwarf was Morrow's company and Murray had Cordell Jigsaw, and they got together to form the Checkout joint venture company. Now, they produced 6 series of the Checkout for the ABC, and the last episode was aired in 2018. And in 2018, the ABC told Morrow and Murray that it proposed to put the program on hiatus. And that came a bit out of the blue. I don't think the parties expected that to occur. So there was quite an immediate response to the decision by the ABC not to do another series. So what happened at that stage, Morrow started to try and persuade the ABC to change its decision about future episodes of the Checkout. And I think the thing that comes across in the judgment is just how strongly he sought to persuade them with tweets and social media comments, fairly aggressive, really trying to shame the ABC into deciding to run a new series. So it was quite a campaign. Then it says that during the same period, and against the possibility that the ABC refused to change its position, he discussed the possibility with ABC of Giant Dwarf, his company, producing a new consumer affairs program. So he's pitching all these different types of programs. And then between February and April 2019, Morrow actually negotiated with Murray to close down the joint venture company and to get Murray to sell his interest in the company to Morrow. Now, the negotiations culminated, this is the negotiations with Murray, in a share sale agreement whereby Murray agreed to sell his interest in the joint venture company to Morrow for $50, and it had some provision in there to pay some money to Murray from the cash budget and some idea that there'd be future royalties. But this was based on the premise that really there was no prospect of the Checkout being made by the ABC. So Murray entered into this share sale agreement really on the belief that the Checkout had no chance. He'd obviously read a lot of the public commentary about the ABC's decision not to continue with the series, and it had all been very negative, and he thought there was no prospect of there being anything further. Now, during those negotiations, Morrow did not mention to Murray that he was and had been negotiating with ABC for quite some time to rebadge the Checkout as a new program called Are You Being Served as the 7 series of the Checkout. And there was a lot of advanced discussions about promoting a new consumer affairs program, very much sharing the same format as the Checkout. So to all intents and purposes, it would have been a new Checkout. Now, what happened was that as soon as the share sale agreement was signed and Cordell or Murray had transferred his shares in the joint venture company to Morrow, then Morrow stepped up his efforts to negotiate a 7th series of the Checkout with the ABC. The ABC was a little bit wary of the situation and said that they didn't want to obviously breach anybody's intellectual property rights. So they made it a condition of commissioning any further series of the Checkout that Murray execute a quitclaim deed, effectively to say that they had no interest in any future production of the Checkout. So Morrow approached Murray and asked him to sign the quit claim, and I think at that stage it was presented largely to Murray as something that was just tying up a few loose ends, that there wasn't really any substantive reason for this quit claim. And I think at that stage Murray tweaked to the fact of what was going on and he refused to sign the quit claim. Now, the allegations made by Morrow were fairly extensive. The first one was the failure to execute the quit claim was a breach of their agreement. Also, that there'd been some misleading representations by Murray about various issues in breach of Section 18 of Australian consumer law, that Murray had published injurious falsehoods about Morrow and his company, that Murray had also breached the confidentiality of a mediation agreement, and then finally that Murray and Cordell had defamed Morrow in a number of respects. The cross claims by Murray were that Giant Dwarf and Morrow had breached an implied term of the joint venture agreement, that it would inform Murray of any future opportunities to produce another series of the Checkout. Also that Morrow and Giant Dwarf engaged in misleading deceptive conduct by failing to advise him of the negotiations with the ABC, and then thirdly that Morrow had breached his director's duties as a director of the joint venture company by not disclosing various opportunities. So the first issue the court had to consider was whether there was an implied term in the joint venture agreement that any prospect of a new program would be disclosed to all the joint venture parties. And here the court clearly thought that there was an implied term. It says there, if either party could, without informing the other, take advantage of an opportunity to produce a further series of the Checkout or equivalent, and thus in effect step outside the joint venture agreement by taking advantage of that opportunity, it would render nugatory the joint venture agreement. So there had to be an implied term in the joint venture agreement in order to give business efficacy to the agreement that any opportunity would be disclosed to all the relevant parties. And when Mr. Morrow sort of tried to explain his way through some of this stuff, the judge didn't find it compelling, because if there hadn't been an implied term in the agreement that this information should be disclosed to the other party, then Mr. Murray would have had, there was no reason for Mr. Morrow not to disclose those communications to Mr. Murray. It was almost a suggestion that Morrow knew there was an implied term to disclose these issues to Mr. Murray, and that's why he hadn't done it. So as you see at the end of this paragraph there, a matter that I find Mr. Morrow did not wish to raise with Mr. Murray in the context of drawing a line on the joint venture. So he consciously decided not to tell Murray of the possibility of a future series. So the findings that were made by the judge in relation to this was that there was a clear fact that there was an opportunity and a genuine prospect of the ABC agreeing to a new show as early as 1st of April 2019. Mr. Morrow did not want the joint venture company to pursue that opportunity as long as Mr. Murray had a 50% share in that joint venture company. Mr. Morrow took the view that he could exercise his sort of veto as a member of the joint venture to disable the joint venture company from pursuing this particular opportunity. And then Mr. Morrow had done all this without revealing to his fellow director his plans to cause that opportunity, which was a real and a genuine prospect, decided not to fill Mr. Murray in on all those issues. So the finding that was made by the judge in relation to this particular issue, was that Giant Dwarf was in breach of the implied term of the joint venture agreement in failing to disclose his opportunity of a new episode or series of the Checkout to Mr. Murray and his company. Now, the other implication of this failure to disclose this information was that Mr. Morrow had actually breached his director's duty. So as you can see there, the duty that Mr. Morrow had was to inform the other joint venturer of the opportunity to produce a further series. And there was a clear conflict of interest because Mr. Morrow was seeking to pursue this interest for himself against the interests of the joint venture company. So he's trying to produce something for his own benefit as opposed to the benefit of the joint venture, and that constituted a breach of his director duties. There was allegation of misleading deceptive conduct, and the issue that was found by the court was that Mr. Morrow had engaged in misleading deceptive conduct by silence in not disclosing to Mr. Murray his discussions with the ABC and keeping those fairly secret. So that was established as a breach, and that gave Mr. Murray some rights under the Australian consumer law. But a conclusion was reached that Murray had not actually engaged in misleading deceptive conduct, mainly because the things that he had said publicly had been proven to be correct. So in a lot of correspondence with the ABC and elsewhere, Mr. Murray saying that Mr. Morrow has breached his director's duties, has engaged in misleading deceptive conduct by not telling me about the prospects of a new program, a new series. So because what Murray had said proved to be correct, that meant that he had actually engaged in misleading deceptive conduct. Another allegation made by Morrow about Murray was that he had engaged in injurious falsehoods. So Murray had made various statements, primarily to the ABC, which were false about Mr. Morrow and his company. And the judge went through those in quite a bit of detail and concluded that Mr. Murray had actually made a number of comments that were false and that were injurious falsehoods. But the problem was that Mr. Morrow was not able to prove that it suffered any loss or damage, because what had occurred is, even though these false statements had been made to the ABC, they were not seen as a catalyst for the ABC ceasing to work with Mr. Morrow on a new episode or new series of the Checkout. Rather, they had had no impact on the ABC's decision to cease exploring this new series. The main reason the ABC stopped being interested in a new series was because of the dispute with Murray and how ugly it was all getting. And I think the realization that Murray had not handed over his rights for the Checkout in full knowledge of the negotiations that had been occurring with ABC. So the ABC decided not to pursue this future series because of all the kerfuffle around the dispute between Morrow and Murray, and not because of anything that Murray had said to them. So that claim made by Morrow failed. The other claim that was made by Morrow was that Murray had defamed him in a number of respects, and there was quite a large number of allegations a large number were dismissed as being true. So a number of the allegations made about breaching directors' duties and engaging in misleading and deceptive conduct weren't defamatory because they were actually true. A number of other statements that Murray had made were found to be true. He argued a qualified privilege argument which failed because not that the ABC was seeking to solicit information, they were having all this information thrust upon it somewhat unwillingly. But there were two particular statements made by Murray in his communication with ABC which were found to be defamatory. The first was an email to Ms. Carnabucci of the ABC on the 5th of July, where, as you can see, there's an allegation there of fraudulent misrepresentation, which was not established. There was no fraud established against Mr. Morrow. There were references there to breach of director's duties, which was established, and misleading deceptive conduct, which was established, but there was no fraudulent misrepresentation. So that was defamatory and not able to be proven as being true. Second was an email to Miss Gilchrist, also of the ABC, on the 12th of August. And there again, you can see a reference to Mr. Morrow being involved in fraud designed to take the shares and IP from a loyal ABC partner for Mr. Murray's company. So again, an allegation of fraud was made in correspondence, which could not be proven to be true. So both of those comments were found to have been defamatory. Now, an interesting comment made by the judge about the defamation allegation was, despite the gravity of the allegations, they don't seem to have affected the ABC's inclination to deal with Mr. Morrow. As you see there, things fell apart between the ABC and Mr. Morrow at the end of 2019 for different reasons, being reasons for which Mr. Morrow can blame no one but himself. So the impact of defamation wasn't to destroy the prospect of the show proceeding. Rather, that occurred through other factors, and factors which the judge put very much at the feet of Mr. Morrow. So the remedies that were decided after this extensive case with so many different allegations were really two. Firstly, Murray had made out the claims that there'd been misleading and deceptive conduct under the Australian consumer law, and as a consequence, he was entitled to a remedy under Section 237 of the Australian consumer law, which is effectively to rescind the share sale agreement, which had transferred his interest in the joint venture company to Mr. Morrow's company. And then Mr. Morrow was actually entitled to general and aggravated damages for the two defamatory comments made in the correspondence to the ABC to a value of $35,000. So a relatively small award of damages for defamation. Now, just a bit of commentary about the case. Firstly, there were a lot of claims raised in this case. Both legal teams threw a lot of stuff at the other side, and it seemed to me that a lot of the claims really lacked merit. And I think it's a bit of a lesson here when you're running litigation, is to focus on your best claims and really try to establish those. Clearly, the more claims you run, the longer the case goes and the more expensive it is for all parties. So it seemed that a lot of claims were dealt with and dismissed by the judge without much effort. So I think it's a lesson there in trying to keep litigation narrowly focused to save your client money and to obviously save the court time. Secondly, it seems strange that a number of the claims were run even though there wasn't any loss. So running a claim of misleading deceptive conduct or injurious falsehood or whatever, the key question you have to ask yourself is not whether you can establish the claim, but whether, if you can establish the claim, are you going to recover any damages? And if the answer is no, then really there's not much point running the claim. So again, there was a few things that really should have just been left out, purely because you could see that even though the claim could be established, it wasn't the causative factor which led to some loss or damage. The loss or damage had arisen for other reasons, and so establishing a claim had no financial benefit for the client. So that seemed a strange thing to me. The other thing was rescinding the agreement seemed like a very poor remedy for Mr. Murray, because effectively the whole opportunity had been lost to run the Checkout series, and rescinding the agreement and giving him back the rights effectively to the Checkout seemed like a very poor remedy. The better remedy would have been damages for the loss of the opportunity, because clearly if the conduct hadn't been engaged in and Murray and Morrow had presented a unified front to the ABC about the new series, then the series most likely would have gone ahead, and then they would have made money. So it seems to me that damages for loss of opportunity would have been a better remedy for Mr. Murray than just rescinding the agreement and getting back some rights, which appear to be pretty well worthless at the moment. There was another thing that was interesting, that Mr. Morrow put on a lot of different character references in the course of his case, and I guess this is really in the context of a defamation action. You're trying to prove that you're a person of high regard, but it seemed to have very limited weight, and I'm not too sure whether there makes a lot of sense in putting on character references from people who don't necessarily understand the substance of the allegations being made in the case. And so you had a variety of people, famous journalists, and actually one of the ACCC commissioners who gave a character reference, head of choice. And so that was an interesting approach to sort of prove that Mr. Morrow had a very high reputation, which had been damaged by statements made. But realistically, the statements have been made in a fairly private capacity. So they've been made in correspondence between Mr. Murray and the ABC. Ironically, the thing that brought them out into the public domain was the litigation. The final thing is there were some stories at the conclusion of the case where journalists are asking both Mr. Morrow and Mr. Murray what their thoughts were about the case, and while Mr. Morrow didn't say very much, Mr. Murray was very triumphant in his comments about the success in the case. But I have a feeling it's not over. I have a suspicion there's going to be some further appeals, and it would be interesting to see what is agitated. Clearly, the size of the damages award seems to be the main issue that Mr. Morrow may seek to appeal, to try and get a larger amount of money out of Mr. Murray. And as I said earlier, the remedy that was sought by Mr. Murray seems fairly worthless. So the question there is whether really they should have pursued a damages payout for loss of opportunity. So that's all I had about the case. If you've got any questions about it, feel free to give us a call or drop us an email. Bye-bye.